just like your breakfast. And then today we'll be having an extensive discussion, one which we've had before, and we'll be having a part 2 of that. We are going to have the law and what every worker must know. You remember that we had this particular discussion extensively, and I was joined or serenaded by top-notch officials from the Labour, that's the Ministry of Employment and Labour, Ministry of Jobs, Employment and Labour, that is, I should say. And they were here, we delved deeper into the law and what every worker must know. I'm talking about none other than Mr. McGeorge Kofi Mensah, who is here with me, and Mr. Godwin Kwanzaa as well, senior Labour officers at the Labour Department of the Ministry of Jobs, Employment and Labour. Guys, you're welcome.
Thank you.
Yes, it's good to have you back in the studios with me again.
It's good to be back as well.
Yes, I mean, the feedback we received from the previous discussions that we had prompted that we needed to continue with this all-important discussion, and that's why we are here once again this morning to keep it going and then to make sure that everyone or every worker is really informed with what is actually going on in the world of work. But before we go on, in case you are watching this particular segment for the first time, we want you to understand what really transpired in the previous one. So we'll go and then we'll take some short clips of the previous excerpts from the previous production that we had on this particular topic. So we'll be back after that particular video.
So I would say that in the interest of the employer, it would be best if you have your workers ready and fit for service. You would bear with me that working 365 days in a year is not an easy task. That is why the law mandates that every worker should be entitled to at least 15 working days. Maybe in your organization, you may have more, you may have better, 20, 30, however, but minimum 15 working days. And you realize that at a point, if you are tired or when you are overwhelmed with work, productivity drops.
That's true.
Productivity drops.
That's true.
So it would be prudent for you to encourage your worker to go on leave and not commit it to cash in any way or in any form. Moreover, the law mandates that as employers or as businessmen and business owners, we are supposed to give notices to our employees at least 30 days before the commencement of their leave. So before the year ends, as the HR or as the business owner, you are supposed to ask your employers to bring in their leave days or schedules so that you can plan, so that if you have two people, both will not go at the same time. Okay. So you can plan and arrange it. And then 30 days before the leave commencement, you give them a notice that, Majorch, or Kwame, you mentioned that you are going on leave on this date. So make sure that you go. Then when the employee goes and he returns reinvigorated. So I would rather advise that instead of committing it to cash, allow the workers to rest. But workers, can it be done? You also make sure you go on leave, go and rest.
Rest. Everybody needs rest. Even God rested on the seventh. So everybody needs rest. You can't work throughout the whole year. No. You need to rest.
Interesting there.
And mind you, in the case where, as a worker, you've been called back from your leave, you are still entitled to the number of days or period you were called back. Maybe they needed you urgently, so you had to forego your leave and return, come and complete an assignment.
So let's say it's 3 hours.
Oh no, not 3 hours. Once you come, you've come for a day. So once you've come, you are entitled to it after the elapsement of your agreed period.
Wow.
Yeah.
Yes, and that is how we had it. I'm sure you heard the famous statement, even God rested on the 7th day. Now, so yes, a kind reminder that we are also streaming live on Facebook and on YouTube. If you go on Facebook and YouTube, you search for Clock TV GH, you'll be able to watch us live and in color. And we're also serving you right on this show. So you can actually send messages, WhatsApp messages on the platforms on your screens over there as well. And then on our WhatsApp, 0500500421, and we'll be kind enough to read them for you. We'll be opening the phone lines in and along this particular session, and then you'll be able to call in, just like you did the other time, to bring in your views, your comments on some of the things that we'll be discussing. But just as a recap, we started by looking at the foundations of labor, and then we saw what labor was, or who someone can be described as qualifies as labor. We looked at the law that governs labor as well, and we looked at working conditions and rights. That's where we actually talked about the leave, the number of leave days. We looked at employment contracts as well. We talked about that a little bit. What are the requirements of a valid employment contract? Must every employment relationship be in writing? We talked about all of these, and you mentioned that there are even agencies that help to explain some of these contracts for us, and our viewers were actually happy. Some of them called in and all that. We talked about leave entitlements, and we were talking about termination and dismissal, and the famous word simpliciter came in, and that was what we were discussing before, and we had to cut that particular show short. So now, let's go back a little bit to the leave entitlements, and then we'll now zone into termination and dismissal.
Okay.
So, just as a recap, how many days annually is a worker entitled to work?
So the law per the Labor Act 651, it's the minimum number of working days or like leave entitlement for each worker in Ghana shouldn't be less than 15. That is 15 working days, not 15 days. 15 working days, like that is 3 weeks. So then that should be the barest. No employer should set below that. So every worker should have or is entitled to at least 15 working days in a year.
So that is the least number of days. Now, there are certain instances where some organizations say that if you've not stayed there for more than a year, you are not entitled to that 15 working days annual leave. So they expect that you stay there you work for 1 whole year without going on leave, and then in the following year, you'll be given that allowance for that 15 days, working days leave. Is that legal?
So we have probationary period. During your probationary period, which is usually a year, that is fine. But after your probationary period of a year, and you are now certified as like a worker with the organization, you are entitled to an annual leave of not less than 15 days.
Not less than 15 days. Yes. That's enlightening there. So the probationary period is usually a year, and that's what we are actually required to do. And apart from that, apart from the normal annual casual leave, that's what you're called, 15 days casual leave. You mentioned also the other time that there are different types of leave that one can be entitled to, which will be outside the 15 days that we mentioned. Can you?
Yeah, so there are other, apart from the annual leave, we have casual leave, we have compassionate leave, and others. Maternity leave is also there. Once you are sick leave is also there. Once you are sick, some employers say that, because you were sick and you took this number of days off, we are subtracting it from your annual leave. But that is not the case. It is not legal. Legally, there are other types of leave, and sick leave is one. So once you are sick and it's certified by a doctor that you are sick, you enjoy your sick leave. Secondly, to maternity leave, like once you are pregnant, all of us know, like once you are pregnant, you go on a few days or a few weeks leave. That is maternity leave. We are human beings. In the course of duty and all of that, things come up. You understand? Relating with family and all of that. So there's something we call compassionate leave. Compassionate leaves are either sick leave, maternity leaves. They are leaves that arise like as humans. If I say as humans, what I mean is, let's say you can wake up one day, you have an emergency, you need to attend to your child or your ward or your spouse or anything. You are not sick. So you can take compassionate leave and attend to that. So there are other forms of leaves.
To add to what he said, for our mothers or for our women, the law allows for an extension of your maternity leave period if complications arise out of the birth. So if it happens that you went through a surgery or there were some complications during birth, the law allows for an extension of that 90 days or 3 months maternity leave period. And then also maybe you gave birth to twins. those are some exceptions that our mothers enjoy. And soon, very soon, our fathers will also start enjoying paternity leave in its essence.
All right, so maybe you give us a little bit of a glimmer of what that paternity leave is going to look like for us.
So it's basically for fathers or for men. We know with the current one, as a father, you cannot take a leave that I wouldn't say a man has given birth, but yes.
My wife has put to bed.
My wife has put to bed, so I'm taking leave for it. Is not clearly stated or clearly allowed, but now it's going to be clearly stipulated that you are allowed maybe 5, 10, 15 working days to also go and help or support your wife in keeping the child safe and healthy within the first period of birth. Yeah.
That's really interesting there. We talk about equity and we talk about equality. Maybe there's one big shout for the men as well.
Yeah.
But away from that, let's look at the number of days. You mentioned 90 days, Mr. McGeorge. 90 days, does that mean 90? Because a lot of discussions are going on in there. Does that mean 90 working days or 90 days?
So it is 12 weeks.
12 weeks.
12 working weeks.
12 working weeks.
Yes, but if we do the calculation, I mean, in our contemporary or in our local settings, 4 weeks to a month, 4 by 3 is 12. So 12 weeks, we assume it is 3 months. So the law stipulates 12 weeks.
Okay.
So the interpretation of the 12 weeks would amount to the 3 months.
Okay.
So not necessarily 90 days, but if you look at the
the reason why the number 90 came in question was if someone is saying 90 working days and I work from Monday to Friday, that means I'm having 5 per week.
No, so it is
and
12,
if I'm going to spread it across,
it is 12 weeks.
Okay.
That works with maternity. But if you are talking of annual leave, that is working days.
Okay.
But when you are talking of maternity, it is in weeks.
Okay.
That doesn't take cognizance of the working days. But if you are talking of annual leave, that is working days.
All right. Viewers, you are being educated, and then you can send your WhatsApp message 0500500421. Let us know your thoughts, your concerns about working conditions. Let us know your thoughts, your concerns about dismissals, whether someone has been dismissed unfairly, employment contracts. They are here. These are senior labor officers who have dedicated their lives to make sure that fairness in the workplace is thriving. And you can also send a message and send your comments and all that, and then they'll be able to attend to them for you. Shortly, we'll be opening the phone lines so that you can also call in to make sure that all your answers concerning working conditions will be answered by them in as much as they can do. And now, before we move on from the leave and entitlements, now let's talk about whether leave can be deferred or converted to cash. Let's say if this whole year I believe that I don't want to go on any leave, and then next year I think that I may need probably instead of the 15 days, I may need 30 days, 30 working days casual leave. Can I defer this year's leave and then carry it over to the next year? Is it legal, or can I convert it to cash if my employer says that this year I'm not sure you can go on any leave? So can I convert it to cash and then benefit from it as well?
So when it comes to converting leaves to cash, the law does not say that you can convert leaves to cash. And about accruing leaves too, the law does not say that leaves can be accrued. So let's say this year you have 30 leave days, and you say, no, I won't take it this year, I'll take it next year. The law is not emphatic on that. However, it boils down to the agreement between the employer, the conditions and services of the employer. There are some situations or peak periods in jobs that your employer will need your services than you going to, or will need all their workers to be available. In such cases, like as I said earlier, the agreement between the employers, you can choose to work and your employer will compensate you, or you can choose to go on leave. It is not mandatory for the employer to say, do not go on leave, I'll give it to you as cash. No, that is illegal. You can, but you, the employee, can decide to if the proposal comes from the employer, you, the employee, can decide to still go on your leave or stay to work, and by which the employer will compensate you or would defer your leave to another period.
Yeah, interesting one there, because the reason why I'm asking this is recently we heard from the news that the IGP said that in December no one is going to go on leave. So that talks about the peak period.
Yes.
Because a lot of activities will be ongoing, and then we'll need a lot more policemen to ensure our security. So that is also legal.
Yes.
Interesting. Now, away from leave and then leave entitlements, let's move to termination and dismissal. Under what grounds can someone's contract, employment contract, be terminated?
So for termination of contract, the law allows for certain conditions to be met before your contract is terminated. So for example, by medical, if for reasons of your health, you cannot be productive or perform as you would, it allows for the employer to sever the relationship to bring in somebody who can boost productivity. Then again, if for any reason at all, you misconduct yourself in the workplace, it is also a legal ground for the employer to stand on and say, I can no more work with you because you've violated certain principles or you violated certain actions upon which I am standing to terminate our agreement. So these are some of the conditions that needs to be satisfied before a termination can be taken effect. Yes.
All right. So then that brings me to the next point, which says that there is fair termination or fair dismissal. There is unfair, then there's unlawful. So are there differences between these three? Obviously, the fair and then unfair, you think that they are opposites. But unfair and then unlawful, what are some of the differences between some of these dismissals?
For the unfair, I'll give the law says that if by reason of my activities as a union member in the organization, you decide to terminate my appointment, it is considered unfair. So two or more people come together to form a union which is advocating for the rights of the workers in the establishment. And you say that these are the kingpins who are pulling the masses to advocate for their rights, which is legally mandated. And you say because if you take them out of the equation,
the rest weaken the union, and then
the rest. So if for that reason you decide to terminate it, it is considered unfair and you can be taken on. Then again, if per reason of my performing my duties, I get into an injury or I am injured, and you say because of my injury you are terminating me because I can't work, it is also grounds to be considered as unfair because I was working for you. If out of that injury, it so happens that I cannot get anywhere within the organization. So maybe I was an operator, but now my hands can't work, but I can perform another duty in the same establishment. The law allows you to change my role to be able to still be in employment, but not to legally say you can't do it. If all other options are exhausted, then you can terminate his or her appointment. So those are some of also the conditions that amounts to fair and unfair termination.
Okay.
So, taking from there, it boils down to the types of dismissal.
Okay.
So, like you see what you said, like unlawful dismissal. Sometimes, some of the employers deliberately create conditions for you to not operate properly or attain your full potential, and by then dismissing you. That is considered constructive dismissal. You are putting, or you are not allowing the employee to fully function, or like you are putting in measures and things to prevent him from achieving his goals. That is considered some constructive dismissal.
Okay, so that has brought us back to the famous terms when it comes to dismissal. But before, is there a difference between termination and dismissal, or they all mean the same thing?
Basically, termination is like you've done something unlawful
Yeah.
and it's been terminated.
Yeah.
As for termination comes from unlawful grounds,
Unlawful, okay.
yes. But dismissals are more or less like agreements. An example would be simpliciter, you like mutual agreement that I would want to quit the job, the employer understands it. But terminations are mostly from unlawful conduct.
Okay, that's interesting there. And then just the other time, you the famous word simpliciter has read its head again. There are different types of dismissal, as you mentioned. You explained constructive dismissal, but then there are some other two that I know of, which is the summary dismissal and then the simpliciter. Can you explain that to us?
So the summary dismissal is when an employee does something or misconducts him or herself. And by that, the employer feels that this misconduct needs you to be shown the exit. So with that, you are dismissed. Let's say an example would be like an employee goes to steal from the employer. Once you are caught, this is a wrongful act.
Yeah.
Once you are caught, the employer has every right to what? Dismiss you. So that is basically summary dismissal. By your conduct, you are dismissed. And that is like termination. You are terminated. But when it comes to simpliciter, simpliciter is mostly in lieu of notice. And like let's say that is mutually agreed. So for an employer to, if you've worked for 3 years and above, you serve your employer 1 month notice.
Okay.
But if you've worked below 3 years, you serve your employer 2 weeks notice. So the simpliciter there are two different types. When you've worked for 3 years, you serve 1 month notice. If you've worked below 3 years, you serve 2 weeks notice. So that's basically what simpliciter talks about. It's just in lieu of notice before you exit.
Okay.
Yeah.
All right. So that brings me to the type of protections that are available, or the types of redress that are available for workers against unlawful termination of their contracts.
So the law allows for you to raise concerns when you feel you've been terminated unfairly. So you can address it internally. Internally, you can exhaust the internal procedures. Once that doesn't resolve into anything substantive and you want to take it further, you can write to the National Labour Commission, and then they would investigate the matter and determine whether it was really lawful or unlawful, or whether the grounds were right or they were not right. And in the case where they find out that it was unlawful for you to be terminated, they can mandate your employer to reinstate you, or depending on how the separation went, if there's a need to separate totally, the agreement will be had, and then the continuation of the process will continue. So that is one layer of protection. It is to write in address to the National Labour Commission and explain yourself or your grievance, and they would attend to it. Alternatively, the law allows for unionism, where two or more form or join or come together to form a union to advocate for the rights and the betterment of workers' conditions. So if there is a union presence there, so those are part of I would say, the internal procedures that needs to be exhausted. The union leaders or the union members dialogue on the issue together with the employer, and as a form of protection, it shields you from feeling neglected or being pinpointed out of the lot. So those are some of the protections that the law gives to workers in the Labour Act 2651.
Well, there are some messages coming in right away, and I'll just pick one of them. This one says, "Hello, please, there's this work at Achimota ABC. I work over there. The working hours was 12 hours. There's no leave given to any employee, and when you confront them about the issue, they just sack you without any letter. Employees are not treated in accordance to the labor law, in accordance with the labor law, that should be. And what can be done about this issue, please? The company isn't registered, not paying any SNIT to the workers. Salary just paid in an envelope. This is coming from Stephen. Stephen texted us from Achimota. Any redress for Stephen?
So I would encourage Stephen to send you the details of his workplace. We are, like we mentioned the previous time, we are mandated to conduct labor inspection. So we would visit the institution, and then we know how we go about it. We go about it professionally. We are not going to pinpoint anybody out. We as part of our random duties we perform. So we would ascertain the truth of the matter, and then we would put advice where it is needed.
So sometimes these things are very dicey. We know employers always, their main motive for engaging in business, that is as another factor of production, is profit. If I'm opening any business, then I should be profiting from it. That's basically what they do. But then juxtaposing that against what should be done, the right things to be done, the right labor procedures and processes that should be in place before they actually do that. That often is a problem. But sometimes the employers also see that their concerns are also left unattended to. How does the labor department respond to this particular one?
So this is where the tripartite comes into place, where the employer on one side, workers on the other side, and then the labor department also, or the labor commission on one hand. And together we dialogue to bring finality to the issue. If you will need a third party if it goes beyond the two, which is the worker and the employer. If it goes beyond you two, then you bring in a third party to mediate or find the best way to go about things.
So just to add up to what he said, the law allows for employers to also form unions. Yes, it's not just employees. So once you are an employer and you are employing 15 or more people, you also can form a union, just like the employees would churn out their grievances through the unions and all of that. You, the employers association, too, can churn out your grievances. So the law is not just a one-sided thing. It protects the interest of the employers as well.
All right. This is also coming from Fred from Kaswa. Fred is saying, hello, good morning. I want to find out if the annual leave applies to private workers too, like bar workers, etc.
Like
bar workers, those who work in the bar.
Yes. As I said from our last presentation, everyone who is working in Ghana with a contract of 6 months and above is entitled to an annual leave. So once again, once you have an employment contract and you are working, you are entitled to an annual leave.
All right, the messages keep coming in, and this also is coming from Julius Ampa from Hacho. Julius Ampa is saying that great discussion there. Good morning to everyone. To my question, what are the most important rights every worker in Ghana should know under the Labour Act? And how can employees practically enforce these rights at the workplace? It seems one guest answered, but elaborate more on that. That's what he's saying.
So to address this, if you would permit me, I would want to read verbatim what the law states.
Thank you. Please do.
So
a lot of messages are coming in there. Keep them coming. This is the reason why they are here. 0500500421 is the number that you can text us. While Mr. Godwin is, you're ready?
Yes, I'm ready.
Okay, let's go.
So the Labour Act 2003, Act 651, it clearly stipulates what the rights of a worker is and what the duties of a worker is. Under Section 10, which talks about the rights of a worker, it says, as a worker, you are entitled to work under satisfactory, safe, and healthy conditions. It is your right. It's not negotiable. Safe, satisfactory, and healthy. So if in your institution or in your undertaking, the conditions there don't satisfy this criteria, please, it is your right. Enjoy it. Exercise it. But I would only caution in exercising, don't over-exercise. Not to over-exercise, but know how to go about it. There's a way to go about it that you can come to a good resolution.
You know, as they say, not to cut you, but your right ends where another person's begins.
Yes.
So, as an employee, your right is ending where the employers also begin. So, there should be always that
moderation and dialogue should be encouraged. Yes.
Exactly.
B, it says it is your right to receive equal pay for equal work of value without distinction of any kind. I think this is self-explanatory.
Can you re-elaborate that?
It is your right to receive equal pay for equal work of value without distinction of any kind.
So now this is talking about, can this be seen to be comparing two workers that are working within the same environment, that do the same task or have the same job description, and then saying that it is my right to receive the pay that's equal to her? Or we just want you to break it down.
Yes, so when it talks about equal pay for equal work, let's say the employer, the main focus of this is discrimination. You don't, like, let's say you and Godwin are doing the same work.
Yeah.
Your contract is same, your everything is same. But because, let's say, Godwin is from, or you have an affiliation with Godwin whatsoever, you are paying Godwin more than you are paying another person. That is clearly discrimination. Both of them are doing the same thing. Both of them are doing the same work. The law says that no, when you are paying people who are doing the same work and all of that, you don't discriminate. You should pay them same value as they are working or what they are valued.
But to add a little to that, that is not to say the fact that you've met me and we are doing the same work, I've been here for 10 years, it means automatically we should take the same pay.
Yeah.
Maybe based off on the organization structure, every year there's an increment. So if I've been here for 10 years and based off on the increment, I'm now taking 1,000 cedis. Doesn't mean when you come, automatically you should be pegged at my 1,000 cedis. You should start from where the basic start is. And then as time goes on, as it progresses, you get to where you need to get to.
That's very interesting there. But just thinking about it out of the vacuum, just because you're talking about this, there should be equal pay for equal work.
Work of value.
So let's say if I have come in, we are both bricklayers. If I have come in as a bricklayer, but then we are laying bricks all the same. You have 10 years of experience, but you ended school in GHS. And I have come in with my degree to come and then lay bricks. Does the equal pay for equal work come in here?
So the equal pay for equal work is held all other things being equal. You have a degree, I have a degree. We sign the same contract and all of that. So the main focus with the equal pay is actually with discrimination, right? If we are doing the same thing and we came the same contract and all of that, you pay me just as you pay. But like, let's say, as you said, if you have like a JSS certificate and somebody has a degree, like you guys are not equal in terms of qualification. So you don't expect or assume to collect equal pay because you are doing the same.
But then again also, the fact that I have degree doesn't mean because of I'm not being paid on my degree, I'm being paid on the work I'm going to do. So you would realize that in most organizations, whether it is SS or the starting pay for this job is 500 cedis. I'm giving an example. And SS can apply, university can apply. The starting pay is 500. If you come, the condition there is 500 regardless of your qualification. So it is not after you've entered and now you come and say, me with degree, that the law doesn't...
The conditions were stated.
Clearly. So once we are all signing on to it, your qualification and things aside, we go by what that is the equal work for equal work of value.
Okay. Yes, the messages are still true.
Okay, then let me finish.
Finish this one and then we'll answer the few
So
messages.
it says that C, it says it is your right to have rest, leisure, and reasonable limitation of working hours and period of holidays with pay as well as remuneration for public holidays. It is your right to form or join a trade union. It is your right to be trained and retrained for the development of your skills. And it is your right to also receive information relevant to your work.
So these are all rights pertaining to
the worker.
This is found in
the Labor Act Section 10.
So Section 10 of Act 651.
Yes.
Okay.
It is under the grand topic of protection of employment. Okay. So it is a way of protecting employers and employees. It has that of employers as well. But this, what I read, was for employees. So that is your level of protection backed by the law.
Okay. So there you have it. Please make sure that you go to Section 10 of Act 651. Every worker should have these at their fingertips so that you cannot be pushed around in and around your workplace. We'll go back to some of the messages. This one is coming from HM Joe. HM Joe says, interesting, insightful and pertinent discussion you people are holding on labor. Kudos. Please, I have some few questions. That's what he says. Is there any carry forward leave in the labor law, or it's subjected to the institution? 2, with a compassionate leave, maternity and sick leave, are there definite or stipulated length of days for it, and how many times can one go for it in a year? Thank you. I think we've tackled this. How many times can one go in a year? Something we've not tackled.
I wanted to find out how many times you can give birth in a year.
But compassionate leave, if let's say I lost, someone loses the mother, and then following after burial, the same year the person loses the brother, then in the same year the person loses the
law doesn't stipulate the number of times, but you can cash in on it at any point in time once it deems the criteria necessary for compassionate leave to be effected.
And to add up, these are natural phenomena. So you cannot actually say that, it is, you have to enjoy compassionate leave for 2 times or 3 times in a year. As humans as we are, there are things that happen that are so unpredicted. So, like as he said, we don't have limitations to that. But make sure you don't abuse it.
Make sure you don't abuse it.
Because
of leave, someone will go and kill their father. Anyway, that's just by the way. This one is also coming. I want us to tackle as many questions that we can have. If you're just tuning in, we are talking about understanding the Ghana labor law, what every worker should know. That is what we are discussing today. And keep your questions or your messages coming in. 0500500421 is the number that you can call us on WhatsApp. You can text us on WhatsApp shortly. I'm sure we'll be opening the phone lines soon, and then you'll be able to drop in your questions, or you'll be able to call in to ask your questions verbatim. This one is coming from Amai Jiwa from Hachu. A lot of people start working without a written contract. What should a worker do if the employer refuses to give them one? And she says, my second question is also that many workers say that they are forced to work overtime without pay. What does the law actually say about overtime?
The first question is, what was her first question?
What do you do when the employer...
So the first question says that a lot of people start working without a written contract. What should a worker do if the employer refuses to give them one?
So just as he read the rights of the employee, it is also the law states the duties of what the employers are supposed to do. And one of the duties of the employers in the Labor Act is to furnish your employees a written contract.
A written?
Yes, written contract. So once your employer is not giving you that, it's against the law. And her second question was, what was her second question?
How many workers say that they are forced to work overtime without pay?
That's the breach of the law. There's no discussion around it. Once you are working overtime, you are supposed to be paid. And even in your contract, there should be a rate of payment and all of that. So once you are not working overtime, that's a breach of the law, and it's unlawful.
I'm sure many employers watching us will be coming for us after this particular show, because what you are revealing as the rights of workers, it's really enlightening. It empowers people to know that we are entitled to this as someone who works in an organization.
I wanted to read a supporting statement to what he said. Section 9, which talks about the duties of the employer. Section 9F, it says, without prejudice to the provisions of this act and any other enactments for the time being in force, any contract of employment or collective agreement, the duties of an employer include the duty to F, furnish the worker with a copy of the worker's contract of employment. So once you violate this, you are in breach of the law. And I would only encourage you, don't be afraid. Don't think you'll be victimized. Visit any labor office and lodge this complaint. We would visit your institution anonymously and then make sure that the right things are done. Again, if you come to Section 35, I think it's a good thing I brought the law today. Section 35, it says that 35(2), a worker in any such undertaking may not be required to do overtime work unless that undertaking has fixed rates of pay for overtime work. So if your institution or your undertaking doesn't have fixed rates of pay for overtime work and they are forcing you, please and please again, visit the nearest labor office wherever you are and lodge this complaint. We will handle it for you.
Someone is asking a question about CBA, but because we've not talked about it, or we'll not go there yet. But there's another question. It says that this is a discussion all media houses must look at. Very interesting. Good morning to everyone. Nana, for someone who wants to report a case to the National Labour Commission, what exact information must they bring along to make the process smooth? This is coming from Mrs. Boafo in Amedome in the Volta region.
They just need to write a letter addressed to the Executive Secretary stating the issue. You just need to state it and then forward it. They would handle the rest. And leave your contact number or how we can easily reach you. It will surprise you to know that people who lodge complaints, they write numbers that even when you call for a follow-up, it doesn't go through. So we are pleading. If you want to lodge a complaint, make sure that the means to reach you is clear and we can easily reach you.
So that is a complaint to be lodged to the Labour Commission. So, mind you, if I want to lodge a complaint to the Labour Department, that's also different.
It's the same.
It's the same.
You only address it to the Chief Labour Officer. The head of the Labour Department is the Chief Labour Officer. And the head of the Labour Commission is the Executive Secretary.
So that means that if I'm lodging a complaint to the Labour Commission, I'm expecting that there will be a tripartite meeting. Or
yes.
But if I'm lodging a complaint to the Labour Department, I'm expecting that maybe it could be just between the two parties.
Yes. Depending on the nature of the issue, it will determine how best we should approach it. If it warrants that we call all parties, we will do that. If it warrants that we shield one party to do this, we will do that. So based off on the issue, it's not categorical as though this is tripartite, this is this, but depending on the issue or the gravity of it, we will determine the best approach to use.
All right. So I'm sure Judith Osei Pokwase is also saying that interesting discussion. Can I get Labour Department's number? I'm sure you give it to them before the program actually ends. Our phone lines are now open. You can call us to join in the conversation. 050-050-0423. 050-050-0423 is the number that you should call to join in this particular conversation, and then we'll be able to answer any questions that you have. You'll be able to pour out your hearts to these senior labor officers who have dedicated their lives to make sure that fairness in the workplace is thriving. Now, let's go on a little bit. I'm sure we may even have to have a part 3 of this because we've not exhausted what we have to do. Now, we talked about duties and rights. You've actually read them through and through. And on the termination and dismissal, this one is also saying what compensation or redress is available when termination is proven to be unfair.
So I think I mentioned that if it's proven to be unfair, what happens is the commission would instruct or direct your employer to reinstate you. There is that. Or based off on how the settlement went, if both parties feel they can't agree or they can't work together, you just separate, but with a compensation that is determined by the commission. But the address is to reinstate. But if it so happens that the relationship has gone beyond repair, then you separate with some sort of compensation.
Interesting one. Mr. McGeorge, let me come to you on the duties and rights. We've talked about the duties of the employee. We've talked about the rights of the employee. We've talked about the duties of the employer. We've talked about the employer. We've talked about the rights of the employee. So now let's talk about the duties of the employee under the Labour Act.
Okay. Let me read so that you would explain.
Yes.
So duties of the employee or a worker. It says 1, work consciously in the lawfully chosen occupation.
Consciously.
Consensuously. Let me read all and then you will summarize.
Okay, yes.
2,
I like this.
you are to report, you as a worker, you are to report for work regularly and punctually. Regularly and punctually.
Employers must be smiling here.
You as a worker, you are to enhance productivity. Enhance productivity. You are to exercise due care in the execution of assigned work. It is your duty as a worker to exercise due care in the execution of assigned work. It is your duty to obey lawful instructions regarding the organization and execution of your work. It is your duty to take reasonable care for safety and health of fellow workers. It is your duty to protect the interest of the employer. And it is your duty to take proper care of the property of the employer entrusted to you, the worker, under the immediate control of the worker.
Yeah. So these duties are pretty self-explanatory because, like, as a worker, you also have to seek the interest of the employer. You don't go to work and work anyhow and expect to be paid and expect things to go well. Once you go to work, you should be going to work regularly. You should be punctual at work. You should work with, you should be conscientious when you are working. You should be focused. All of these things enhances productivity. And the long term is that your duties should make the employer happy employing you. You understand? You can't go to work and not care about the properties of the employer. You can't go to work and not care about the interest of the employer. You just come and sit there and you are not productive and all of that. The law doesn't agree or doesn't condone such things.
Okay. So conversely, we've talked about the duties of the employer, and then we've also talked about the responsibility of the employer. So now we've also talked about the basic rights that every worker should know. So I think we've exhausted quite a lot of the questions that are coming in over here. This one is also coming. There are a lot of questions, and I want us to continue from the questions coming on. There's something interesting discussion going on. I'm really learning a lot. What I want to understand here is, before going ahead to report a complaint, what peaceful steps can I take as a worker when I have a disagreement with my employer?
So, I don't know the nature of the work. If it is such that there is an HR or there is an administrator, you can verbally inform the person. That is maybe for the first time, you can verbally address the issue. If it so happens that it wasn't resolved and it happens or it occurs again, you can put it in writing formally to the employer or the HR or whoever is administering over the place. And if all those then again, if there's the presence of a union, you'd channel it through the union as well. But if all these processes are exhausted and still no resolution has been made, then you can bring it. But if it so happens also that all these structures are not there, you can directly just walk to us and then we would handle it for you.
All right.
So just to add up, we would also encourage employers to have channels of which grievances can be redressed, because most employers, they don't have such things. That is when you see employees escalating the issues to the authorities, the labor department and the commissions and all of that. But once there are proper channels through which grievances can be redressed, the employees are encouraged to exhaust all those means before taking it out of the.
And if I may,
please may.
So the Schedule 1 of the Labour Act, it gives a template, the barest minimum of how a contract of employment should look like under the Schedule 1. Schedule 1, 11. Let me read 11. It says, the disciplinary rules applicable to you are this is how, in your written statements of contract of employment, it should include the disciplinary rules in your organization. It should also 12. It says the procedure for dealing with any grievance or disputes is. So as part of the contract of employment that employers are preparing or should prepare, they should clearly state some of these things in there so that when an issue arises, we just activate it. And it won't be as if there's a blanket or there's nothing that addresses it in any way. This is the barest minimum. So at least employers should have this in their contract office, and then employees should also make sure that some of these things are stated therein.
And this is coming from the Labour Act
651.
651, Schedule 1.
Schedule 1,
okay.
Yes.
Quite a lot of messages coming in here. This one says that interesting discussion going on. I'm really learning a lot. Blessing is saying that how can a worker know if their employer is actually paying their SNIT?
I think it's mandated on you as the employee or the worker. You can visit the SNIT offices anywhere and wherever you are, and then make a request to see your SNIT statements. If they print it out for you, you would know whether they are being paid or they are not being paid. So it is incumbent on you yourself to walk to any SNIT office. Please don't wait till 60 years or 59, 3 months before you visit the SNIT office. Periodically, visit any SNIT office and ensure that your SNIT payments are being made. It will surprise you to know that sometimes there are infractions or there are certain gaps in the SNIT payments. So it will be prudent that you address them early and immediate than to wait till when you are 60 years and maybe you work with an organization. The organization has collapsed over 10, 15 years ago. SNIT can't find them. They didn't pay your SNIT. SNIT can't find them. Now that you are 60, SNIT can't find them to charge them to pay you. So just do the needful whilst in employment.
All right, so this is an imploration that we are imploring you that go and check your SNIT. Don't wait till you're about to retire before you actually seek the interest of your SNIT. Not only SNIT, go and check your mandatory Tier 2 occupational pension scheme. Make sure that you look for your corporate trustees and check whether they are indeed paying your Tier 2, whether they are indeed paying your SNIT. Otherwise, when you retire, it's quite miserable. Just as you're saying. But then this one is coming from Kelvin from La Paz. Good morning, sir. Please, I would like to know, as an employee and a union representative for a branch of a company, what is my right after I contributed on a union platform in the well-being of workers of the union chairman? And the union chairman forwarded my contribution to the HR for disciplinary action to be taken against me. This is coming from Kelvin from La Paz. I'm sure he doesn't want to show his actual name, so he said this so that he went on the union platform and then went to give out his grievances. The HR was sitting there, probably took a video of it, and then has forwarded it to HR, and then now he's being threatened with disciplinary action, or maybe he's facing the disciplinary action from HR. How then do we go?
So, if you look at today I'm using the book, but I just want us to be explicitly clear on what we are to do and what we are not to do. But under unfair termination. An employment of a worker should not be unfairly terminated. A worker's employment is terminated unfairly if the only reason for termination is that one, the worker intends to join or has ceased to be a member of a trade union or intends to take part in activities of a trade union. So in your activism as a union member, if it is established that it was because of this that your employer wants to take punitive actions against you, it can be considered unfair, and you can take your employer on. So that's he shouldn't be afraid if it is determined that indeed he was sacked or he was let go because of his union activities.
So right now he's facing disciplinary
Actions.
Yes.
And it is illegal, actually.
It is illegal.
Yes.
It is illegal for you to, just as it said, you are doing union activities and your employer is taking punitive actions against you. That is not done. So he has the right to take this forward.
I would want to ask, is he having an issue with his union chairman? Because I won't understand.
Why your
We are
union
collectively
chairman-
seeking
Yes.
the best interest of the people. So maybe there are underlying issues, but in the absence of that,
It's illegal.
it's
But these are some of the real issues that people actually face and go through. Because today, when we just opened the platform for questions, and then the phone lines are also open 0500500423. You can call in. I saw that some people called, but then the lines were dropped. But you can still call in. The lines are being jumped, but keep calling, and then you'll be able to get through to us. But these are some of the real issues that people face. So whenever we talk about labor and we talk about issues regarding employment, that is where usually we have a lot of questions coming through. This particular person, if I should show you the messages, has sent 4 different messages because these are things that are on the hearts of people that they want to bring out. And I really want to appreciate you, you two especially, because time and time again when we call you, you are ever present to help and answer some of these questions. This one says that I'm Joshua. I have a few questions to ask. What are the laws regarding equal pay for equal work? I think we've tackled that. How do I protect my intellectual property rights as an employee? What are the rules regarding employee data protection and confidentiality? And then can I negotiate my employment contract? And if so, what terms can I negotiate?
Okay, so let's take it one after the other.
Yes, so we are not taking the first one because we've actually answered it. How do I protect my intellectual property rights as an employee?
I think there's an intellectual property law.
Yes.
So I think it governs.
That governs
Yes.
it.
So
Okay,
that
so-
would be the best
Yes.
way to go about it.
So and then employee data protection and confidentiality, that also goes with the Data Protection
Yes.
Act. So there are the principles of data protection that are there. I'm sure maybe if you can actually text us after the program, we can take you
I
through
would
that.
also want to find out the intellectual property. Is it that me as the employer I've trained and retrained you as I'm supposed to do, and now you say it is your intellectual property, or it is personal studies that I'm employing or that I'm using that is considered intellectual property? If you can give that distinction, maybe.
So
we can.
Joshua, if you're hearing us, you can
Because
actually
if
give us.
me as an employer, I train and retrain you, and now you say it is your intellectual property, I will be a bit baffled.
Yeah. And then finally, he says that, can I negotiate my employment contract? And if so, what terms can I negotiate? I'm sure you can pretty much negotiate every term
Yes.
of your employment contract. So that is it with Joshua. 5 messages coming from this particular person. This one says that, thank you, Joe. HM Joe says, thank you, guys. But please, my first question on carry forward leave wasn't answered. What should be done if a worker is mostly sick and is the only person assigned performing his or her role? Now, the first question that HM sent was, is there any carry forward leave in the labor law or is subjected to the institution?
So I explained this from the earlier conversation that leaves are not carried forward. However, the law it's not emphatic on accrued leave or carry forward leaves. However, it all boils down to the internal agreement between your employer. So at seasons or peak periods where your employer needs you to work and you cannot go on leave, he can actually defer your leave to another time for you. So it's more or less like an internal thing. However, you are entitled to the leave. So it boils down to the internal agreement between you, the employee, and the employer.
Okay, so HMG, I'm sure you've been satisfied with that particular answer. This one says that when an employer refuses to hire someone because of disability, what steps can the person take to challenge that discrimination?
When the employer refuses to
employ someone because of disability, or maybe
it is not encouraged. However, there is the right of the employer to employ whoever he or she wants to employ. However, there are incentives that are given to employers who employ people living with disabilities. But it's not incumbent. The law doesn't say that you as an employer, you need to employ this type of person. If you don't employ them, we can take punitive actions or you are in breach of the law. No, there's nothing like that. However, we can just encourage, or the law encourages like employers to employ people living with disabilities.
All right. So I'm sure we'll take a few messages and we'll continue. This one says, good morning, everyone. Please ask this for me. If workers are unsure whether they belong to an essential service, where can they practically verify this before planning any strike action? This is coming from Mr. Ernest Opoku in Sunyani. If workers are unsure whether they belong to an essential service or a union, where can they practically verify this before planning any strike action?
So I think essential services are services that, in the absence of loss, there can be loss of life, or there can be any damage to somebody or to the nation or to anything. So if he checks his operations, does it qualify to be an essential service? So on top of my head, I would say the health service is an essential service. I think utilities, the water and the electricity, they are also considered essential service. I think the security as well are also part of. So if your operations is within this domain, you qualify to be an essential service.
Okay, nice one. This one is coming from Mr. Emmanuel Afum. He says, interesting discussion. Emmanuel Afum is my name, from Aketia, and an executive of the Ghana Deaf Association. To my question, if an employee with disability needs reasonable accommodation like adjusted working hours or tools, how can they formally request that under Ghana's labor rules?
So this won't form under the labor rules, but they will form under the internal procedures and processes of the institution or organization. So based off on the operations, if you believe or if you think there's a need to have certain measures or certain concessions between you, the employer, or you, the employee, and the worker, you can reach into an agreement with them. That is why we always say that dialogue in the workspace is very essential. How you can negotiate or how you can dialogue certain challenges you are facing to your employer, and also understand from the standpoint of the employer that he is facing these challenges. This cost is going to come to him. So is he ready for it, or can he contain it? Then you reach a consensus, and then you find the best way forward.
All right, this one says, thank you, Cocoa Digest, for this discussion. I've worked with an organization where I was almost not employed because of my cultural background. So I want to ask, is it legal for an employer to refuse to hire someone because of their tribal background? Since you said an employer can employ anybody that he wants.
So if you say the employer refuses to hire you, that means you are not in employment yet. There's no employment contract. And once again, all of these things, the employer has the right to employ whoever he or she wants to employ. However, we encourage employers or people not to discriminate based on race, religion, and cultural background. Everybody should be given a free and fair environment to work or to be employed. So it's not like the employer there's nothing in the law that says that employer should employ people from this race, people not from this race, and all of that. He has the sole right, relies on him to employ whoever he wants to. So we only encourage that employers should focus more on competence, who can do the work, other than looking at like racial backgrounds or cultural backgrounds and all of that.
This one is also, I think we'll take this last one and then we'll move on. She says, thank you very much. Please, Nana, ask your labor officers, they are senior labor officers. Nana, please ask your senior labor officers if contract or part-time workers have SNIT rights too. Contract or part-time workers.
Yes. SNIT is once you are paying, once you are working, your SNIT needs to be paid. And that jurisdiction falls with the SNIT. So SNIT also have inspectors that go around to check their SNIT contribution of workers and all of that. So once you are in any form of employment, your employer should be able to pay your SNIT for you.
This one is really important because it says, "Hi, good morning. Please, I want to hide my name. Please, how many hours are you to work in a week? Because we work 48 hours in a week, but they mark us only 40 hours.
Okay. So, okay, let me take a previous issue and come back to the working hours. So under section 127, I think La Paz, Stephen from La Paz, section 127 talks about discrimination. It says a person who discriminates against any person with respect to the employment or conditions of employment because that other person is a member or an officer of a trade union is guilty of unfair labor practice.
So the chairman has to be looked at.
Unfair labor practice. So he can take them on under that section. And now to the hours of work. The law under section 33, I read.
Today we call you the law.
The hours of work of a worker shall be a maximum of 8 hours a day or 40 hours a week, except in cases expressly provided for in this act. So the law is clear: 8 hours a day, 40 hours a week. If there is any violation and you know anything outside or beyond this period should be considered as overtime. So if it is not being considered as that, he should just make an anonymous complaint and we will take it on.
All right, so please, if you are watching us, you can just make sure that you make an anonymous complaint and then they will take them on, because once you've worked, they cannot mark you less than that particular number of hours that you have. This one says that, I think we've answered these ones already. So please, I'm sure those of you who tried calling in, we experienced a few technical glitches with our phone lines, so apologies for that. But then you can keep your messages coming in. We'll forward them to the senior labor officers here, and then they'll answer them, and then we'll forward them back to you. I'm sure before leaving, they'll leave some phone lines that you can actually call and then reach them directly, and then they'll be able to answer whatever questions that you have. We have to go in a bit, but let's just look at, there's this one. Someone asked about CBA, collective bargaining agreements, and how it does function in the Ghanaian workplace. Can you just enlighten us a little bit, or it's not within your jurisdiction?
Okay. It is.
Okay, yes.
So the CBA, which is the collective bargaining agreement, is an agreement between an employer and a union or an the workers. So, how do I put it? It is an agreement that stipulates the rights and obligations of both parties. I want to take it one after the other. So, to have a collective bargaining agreement, you should have a collective bargaining certificate. And the collective bargaining certificate is issued by the chief labor officer. So, as workers in your establishment, you need, if you come together as a union to advocate for your rights, you need to write to the chief labor officer, and you'll be duly registered or recognized. Then you can advocate for the people you are covering. And once you advocate and you reach an agreement, it is considered the collective bargaining agreement. Yes, okay. So you need a certificate to get an agreement. So it's basically just the agreement between those two parties.
Okay. So how does the National Labour Commission handle issues between employers and employees? I'm sure we've actually talked about that because of time. Now, okay, just as a follow-up to the last question that we asked, the person that wanted to hide the name says that, yes, we work 8 hours a day and 48 hours a week, and they told us one day will be marked as overtime, and then they pay it, and then they pay for only 3 months when we started the 8 hours.
Come again with that.
Yes, we work 8 hours a day.
Yes.
And 48 hours a week.
So that means they work six days in a week.
6 days in a week. And told us that one day will be marked as overtime.
Okay.
Just one day.
Yes.
Okay.
So maybe out of they'll pay for 40 days, and then they'll mark the extra 8 as overtime.
Overtime, yeah.
And they pay for only 3 months when we started the 8 hours.
So they've paid so far they've worked for a while, but so far the overtime they've only paid for 3 months.
I'm sure. So this particular one person sending us a message, we will. He's confirmed that it's 6 days a week. So we'll give your numbers out, and then he'll be able to contact you because our time is really fast spent, and I would like to take your few words. Maybe you leave the numbers that we can contact you in. Maybe we'll be here for a part 3, who knows? But then let's just have your final words because our time is fast spent.
Oh, okay. So we would encourage every worker and every employer to fall on the labor laws, because there are things in the laws that guides our employment and how we should work. So I would entreat that it is not only for employees. You employers too are like the onus falls on you to also check with the law and see, and let's all do the right thing so we can have a peaceful working environment.
All right, Mr. Godwin.
Yes.
Mr. Godwin Cancer.
Yes, I would say that employees or workers, we need to take charge of our future. We need to make sure that we shouldn't give the chance for people to exploit us. Let us know our rights and ensure that the right things are done. And I would want to conclude with a big thank you to the Chief Labour Officer, Mr. Dauda Ibrahim Brahima, who has given us this opportunity to be here and share with your viewers.
All right, we promise that you're going to give out the phone lines that they can actually reach you on. So please, if you may, if you want to contact these chief or senior labor officers, I should say, the numbers to call are
020-914-0825. I repeat, 020-914-0825.
Or you can actually call in or send a WhatsApp message on our Clock TV lines, and then we'll be able to forward whatever discussion or whatever conversation you want to have with them. The number is displayed on your screen there, 0500500421. So I'd want to say a very big thank you to you, Mr. Godwin Cancer, and then to you, Mr. McGeorge Mensah. Thank you very much for coming, and then thank you very much for enlightening us. I'm sure definitely we'll be here once again to exhaust the rest of this inexhaustible discussion that we've been having. Viewers, it's been a very good time on the Cocoa Digest Morning Show. Today, we talked about the law and what every Ghanaian worker must know. We've dived extensively. This is the second part that we did. Initially, we talked about what labor is. Today, we've come to talk about dismissals. We've come to talk about the redress that you can seek. We've come to talk about the rights and the rights of responsibilities for employers and employees. It's been an all-enriching discussion and kind courtesy by guests from the Labour Department, Mr. McGeorge Kofi Mensah and then Mr. Godwin Cancer. And thank you very much for being with us through it all. My name is Nanaya Awasari, and this is how we call it a day on the Cocoa Digest Morning Show.